Case 17-1666, USA versus Josette Buendia. Oral argument not to exceed 15 minutes per side. And Mr. Fink for the appellant. Thank you.
Good morning, Your Honors. May it please the Court. My name is Wade Fink, and I am representing the defendant appellant, Josette Buendia, in this appeal as of right. Your Honors, we have assigned a number of errors to the District Court following this jury trial and conviction of Ms. Buendia, and I'm prepared to take questions on any of the issues, but I think a lot of them flow from the relevancy determination with regard to corrupt intent. So in my affirmative argument here, I'm going to focus on the issue of whether Ms. Buendia's expenditures or the purpose of the arrangement she had with Mr. Shai was relevant evidence as it pertains to corrupt intent. And also focus on the government's deliberate and willful path that we were led down to believe that they believed it was relevant evidence, put in affirmative evidence, and then ask the district court to shield them from rebuttal evidence from us. Your Honors, I've been in a courtroom since I've been 7 years old, and I heard my father say many a times, Neil Fink from Berger versus United States, that a prosecutor is entitled to strike hard blows, but not foul ones. The conduct of this case was foul.
What was the foulest conduct that was made? Let's start with the toughest one against the government.
Yes, absolutely, Judge. From the indictment, from the grand jury through the indictment, the government created a path that said the way that Ms. Buendia spent money was relevant to whether she acted corruptly. And for paragraph 17 of the indictment, for example, Judge Seiler, the indictment reads that she tried to make the expenditures appear legitimate by saying they were for school purposes. In other words, putting in issue the purpose of this arrangement she had with Mr. Shai. Then we got to the...
Why wouldn't that instead just show that she was trying to hide it?
It may, Your Honor, it may, but it certainly puts in issue, at a minimum, the purpose being relevant, at least as far as the government's concerned, in their charging document, which governs the action. And then it went much further, though, Judge Rogers, because in the first day of trial, when the receipts that are at issue in this case, the receipts documenting the money that Ms. Buendia spent on the school, not on herself, government didn't make any motion, didn't make any objection. In fact, defense counsel raised this defense in our opening statement. Again,
it's in the opening statement. You have to object in the opening statement.
I'm not saying you have to, Judge Rogers. I'm
looking at you were asked what the worst thing is that.
All right, I'll cut to the.
In the opening statement, you're not.
Absolutely, Judge. I'll cut to the chase. I'll cut to the chase, Judge. The first time an objection was mentioned in this case was by the government when there was a conversation on the record about when defense witnesses would be available. The government said, I don't think these witnesses are relevant because the conduct of Ms. Buendia and what she did with the money after this arrangement is irrelevant. That's when they made their objection. Very next sentence, or the very next thing that happened in the trial transcript, in fact, the next witness was a witness named Jonathan Saltz. And Jonathan Saltz is a massage therapist. He's a masseuse. And the only purpose of his testimony was for the government to put into evidence that Ms. Buendia spent this money on massages. That she took the gift cards, spent it on herself, and spent it on her staff. In other words, not for school purposes. There was no other purpose for that testimony. There was no other relevance. And it went further than that. That's right after they made the objection that it wasn't relevant. But it went further because they had Agent Rosenthal testify, who was the investigator. The government affirmatively asked Ms. Rosenthal, without objection because we thought it was relevant, asked her why she spent, or where she spent the money and why. She said she admitted to her that she spent it at gas stations, that she might have spent it on nail salons. In other words, the government is affirmatively asking in their case in chief about how the expenditures were made.
So let me just ask a question. So let's assume, I know you believe that the government sort of intentionally led you down this path to believe that this would be a defense and then it wasn't. But let's assume that everybody in the courtroom is acting in good faith and everybody thinks mistakenly, perhaps, that in order to prove the element of corruptness, you have to prove spent with bad purpose, the ill-gotten funds were spent for a bad purpose rather than a good purpose. And everybody believes that honestly, and so the same things happen, they put on the massage therapist, and then, late in the day, the government realizes, oh my gosh, that's the wrong definition of corrupt, that's like a colloquial definition, but not a legal definition, and thereby goes to the judge and says, wow, all this evidence isn't relevant, and the judge says, Eureka, you're right. Do you still somehow claim that you have a right to present a defense that is not in accordance with the actual meaning of the statute just because everyone was mistaken at the beginning? And if the answer is no in the case of a mistake, what's your best case that you are allowed to do it in the case of what you claim to be a deliberate leading you down the wrong path?
Of course. Judge, let me say this at the outset. We think the evidence was relevant. And we think Rooney's are illustrative in that regard, and I'm happy to discuss that. So I don't want to concede that it's not relevant. But directly to answer your question, the government, if we're assuming good faith and this was an honest mistake, at a minimum invited the error to happen or invited the rebuttal because it's axiomatic that once you open the door on an evidentiary issue, at a minimum, someone has the fundamental Sixth Amendment right to defend themselves. So if in the chart, I'm sorry, Judge.
Go ahead.
The government takes your argument and gives an answer. I wonder if the answer is persuasive. I'm just reading from the brief here. Because they take your argument and they say, look, we didn't call Saltz a massage therapist for the limited purpose of showing that Buendia was the person who spent $3,000 in kickbacks. Saltz testified that Buendia purchased $200 in prepaid massages using a card. This matched the records for one of the gift cards Shai provided to Buendia in conjunction with his cooperation. So the idea is that it was to show that she was using the money that had been provided in the cards. That's not the same thing as saying that massage is not a good basis for this to be used. That's their argument.
Absolutely, Judge, and I recognize that what my response would be is that's a post hoc invention to try to justify why they called the massage therapist because there was ample evidence. In fact, defense counsel, trial counsel conceded in our opening statement that these gift cards and cash were received. There's no dispute about this.
They can still show stuff that you've conceded. The law is pretty clear, right?
Absolutely, Judge.
They have picked things that are less complimentary to your client. But they can do that too, as long as it's relevant.
Yes, under Old Chief, Judge, you're entitled to a rich narrative. You can't concede away, stipulate. I understand that.
I'm trying to show that she's the person who signed this, right?
Right.
Get this person who does massages rather than somebody who does field trips.
Let me say this, Judge. First, I respect the argument, and that is the argument. I think it's post hoc, and I think if you take it in the context of how the conduct of this trial went, that was the purpose. But I'll say this. There's more egregious conduct in our view.
Okay, but that's why Judge Seiler's asking. What's the worst?
Well, I would still submit that was bad, but respectfully, I would say this too. Once they made the objection, Judge, when the defense was putting on its case in chief and rebutting the evidence that the government had already put into evidence, they made the objection a relevancy objection, and Judge Stee then granted the relevancy objection and said how she spent the money, the purpose for which she took the money is not relevant. Once that decision was made, the government in their closing argument made use of the evidence that they put in their case in chief that had just been determined irrelevant. That kind of that is a foul blow. That is, I'm sorry, Judge? The trial counsel didn't object to that because they want to call attention to it in the closing argument, but it's an example of the government using this sword, using the ability of this evidence they've gotten in, and then we're defenseless. They asked the trial court for a shield, and they got one, but they still had the sword at closing argument of the evidence that they put in. It reminds me of the Monty Python skit with the Black Knight. You have somebody totally defenseless, can't rebut the evidence the prosecution has put in, and they're making use of it at closing argument. I don't think that kind of conduct or that kind of behavior is tolerable in an American courtroom because...
Were the instructions impermissible? If you say something in closing argument that relies on something that's irrelevant and it's not objected to, but the instructions are okay,
Well,
then you've got to trust that the jury follows the instructions, right?
of course, Judge, and we think the jury was misinstructed based on that relevancy determination.
Well, then that's the relevancy.
Of course, and a lot of this flows from this, but I think it's important in context that the government made use of this evidence. But I will say, and I might have to use some of my rebuttal time, but the relevance, we rely on Rooney. We think that Rooney is the same dynamic, if I could finish this thought, if that's okay with the panel. The dynamic in Rooney with a agent of federal funds in Rooney negotiating a deal with a commercial contractor on the other to extract an additional benefit to him personally as an authorized agent of the government is the same issue here. And the Second Circuit said that it's irrelevant as to whether there was a benefit to the government as well. Here there was a benefit to the government, at least we proffered to show that.
It's counterintuitive, and I wonder if you have some case law other than the Second Circuit.
Well, Judge,
You see why it sounds like, it's like you can kind of defraud the government if you use the funds for something similar to what the government might have wanted to spend them on.
well,
There's no defense to defrauding the government.
Judge, I would say this. The Second Circuit said that...
I mean, apart from the Second Circuit, is there anything? If that's what they said, I mean, we can go
No,
back
I
and
understand, Judge.
see whether it's different or see whether it's the same, but we don't really have to because the Second Circuit decision. And just
It's illustrative,
on its face,
absolutely.
it looks wrong.
It's
If it says that.
It's certainly illustrative, and this court absolutely can reject its reasoning, but I would submit to the court that you'd have to reject its reasoning to find differently. I mean, I don't think there's a distinguishing factor to be made.
All right.
I'll reserve the balance. Thank you, Judge.
Good morning, and may it please the Court. Shane Crawley for the United States. I'd like to start with where appellant counsel ended, and that was the Rooney case. And Rooney is distinguishable because it involved a private individual who did not have the same duty of care that Josette Buendia did here as a principal and employee of a local government. And that was the reason that the Second Circuit relied on, and that's why it's completely distinguishable here, is they questioned whether she had, or whether Rooney had, a duty that had been breached. Here there is no question that Josette Buendia had a duty to follow the Detroit Public Schools procurement regulations in selecting which vendors. Those regulations required that she not accept solicitation or accept kickbacks or bribes or any gift of any sort over $100, and also that she not pay a vendor for products that were not received, either in whole or in part. And frankly, that is the crux of what happened here. The testimony was quite clear that Josette Buendia specifically selected Norman Shai as a vendor and did so in order to get these kickbacks. And we know this because the goods were habitually not delivered. The procurement process required...
Sign that they were delivered?
Frequently, she was directing a subordinate. So the process was this. A subordinate would make the request, and then she would approve it.
For instance, for what?
For example, they make reference to these raised line papers, some sort of... So you ordered...
What can they buy? I mean, it's a few $100s worth of pages, right? Something like that, or $1,000 maybe?
Several times the purchase orders were in $1,000, $5,000, $10,000 increments. I believe the sum total... I think there were textbooks and other items as well. I think the sum total during her tenure was $125,000 and change. So requests were made either by her or subordinate, and then she, as the approving authority, would sign off on those, and at that point a purchase order would be issued. Shai would either deliver none of the goods ordered or some of the goods ordered. Now, Detroit Public Schools required that upon receipt of the goods that they be inspected, and then once, if you order 100 textbooks, all 100 textbooks are delivered, then...
What if they aren't? What if 50 are delivered?
Then you're not supposed to pay the purchase order or the invoice until all 100 are delivered.
You mean she?
The school employee is not supposed to sign off on it to say they're all ordered, they're all received.
So that she knew that they were not being signed off on? I'm just trying to get at the nature of her fraud.
Absolutely. She was actually instructing her subordinates to indicate that they had been received, and even when they had not been, and frequently was not even...
If they had not done that, they would have... Something would have happened. There had been an adjustment.
Had there not been, then he would not have been paid. At all, until the full receipt was delivered, until the full...
Testify at all, did she?
She did not testify, Your Honor, and frankly, that was the big issue with much of the evidentiary rulings that came into play, is that the wrong witnesses took the stand in order to introduce the sort of evidence that they wanted to. At the end of the day, this was a jury nullification defense, pure and simple. They wanted...
Kind of a Robin Hood defense, isn't it?
It is absolutely a Robin Hood defense. There's no question she was taking bribes. In fact, she said that she was taking bribes during her opening statement. The question was that there was a misunderstanding as far as the corrupt intent. They wanted to transition that corrupt from the act itself, which is breach of duty in order to give a benefit either to her or to Norman Shai in exchange for these kickbacks. Wanted to shift that corrupt to the way that the money was being spent. In other words, yes, I was taking bribes, but I didn't have a corrupt purpose in doing that. I was using it to benefit the schools. Now, leaving aside the fact that these were Title I funds, and under the federal law, these Title I funds can only be used for specific purposes, and while a Nintendo Wii, a karaoke machine, or massages for employees may well benefit the school, those are not legitimate ways to spend Title I.
But then you put on the testimony of the provider of the massages, right?
That's correct, and those were specific.
Put on the testimony of something a little bit more sympathetic to show that she's signing these things.
Your Honor,
I guess it's within your discretion to pick something that looks like she was spending it on frivolous or selfish purposes.
the massage therapy...
I'm not saying that's wrong. I'm just asking if that's what's going on.
So what was going on is that there was this long-running conspiracy, and then in February of 2015, there were 6 gift cards provided through Norman Shai to Buendia. Now, these were done when Norman Shai was acting as a cooperator, and so the government was able to track how she was spending this money. So this was effectively evidence that showed that, yes, she received it, and she used it. So it was kind of tying together the complete story.
You could have picked some other way in which she used it, which would have looked better. I think that's the guts of this argument.
Would have looked better for the defendant.
Yeah, would have looked better for the defendants, exactly.
Well, in fairness, Your Honor, I think actually this, in some ways, could be construed as looking better for the defendant, because her argument was... Well, Your Honor, her argument, taking it in the...
It's awful, you know, it doesn't pass the smell test, right?
She said she did it for the tired teachers who worked under it, and she was up for
In the light most favorable to Josette Buendia, which is not the standard, but let's just assume, she said that she took this money and bought massages for her teachers, which retired for an administrative day, in order that they would be well rested and pay attention and get the most out of it. So while I certainly recognize...
Laughable, right? So you pick a laughable example, and you could have... This is what seems to be the crux of the opposition. I'm not sure it has a legal basis, but I can kind of see where they're coming from. It looks, when you pick a laughable example, it looks like you have to demonstrate that there's a laughable example.
Your Honor, I'm not sure what else we could have picked, because the other way she used the money was to get her nails done and to buy gas for her car.
Other things that she did, like fix the roof and...
Well, that's the other problem, Your Honor, and that's frankly the level of abstraction. So the government was introducing specific ways that those gift cards were used. Josette Buendia talked in generalities, and that was really where all of the evidentiary rulings come back into play. She talked about generalities, and the best example would be, this was, I believe, Evelyn Smith, who was a retired teacher, and talked about how this was a heavily impoverished school, Bennett Elementary, and that there were students that came to school every day that didn't have hats or gloves or coats, and it's Detroit and it's cold, and so Buendia would provide them coats or gloves, no questions asked. That is admirable, but there was no direct connection to where those came from. There was no direct connection to show that money from a bribe was used to buy those coats to then provide to the student.
If they tried to show it, though, you would have objected to it.
Perhaps, Your Honor, but my point is, most likely, Your Honor, my point is, the evidence was at a level of generality in which it was not relevant because there was no specific connection to a bribe, and that was because the wrong witnesses were trying to introduce this evidence. The reality was that the only way that they could show that any of the bribes were used, and the reason why they claim this is so unfair is because they were using the wrong witnesses. That's the issue at the end of the day.
Yeah, we can look at the exact language and see whether it conforms to his description or to yours.
But even if they'd used the right witnesses, your position is that corruptly doesn't mean for bad outcomes. So even if they had used the right witness and the right witness got on the stand and said, I used this gift card to buy paper for the students, you would say it doesn't matter. There was a procurement process for buying paper.
Yes.
It's supposed to be done through a competitive bid process, blah, blah, blah. It doesn't matter. It's still corrupt.
That's right, Your Honor.
Even if she could have gone and bought, from the government procurement process, she would have spent $100 and she could get the same amount of paper at Staples for $50 and thus buy twice as much paper. You'd still say that's corrupt.
I would say that there was a process in place to make sure that the government regulations are followed and that she went outside of those and was trying to justify it after the fact. And this court has stated...
Corrupt is what the question is.
Yes, Your Honor. Well, no, actually, just to clarify, that in and of itself would not be corrupt just to go outside of the process. So the issue where the corruptness comes into play is when you're breaching a duty in order to give a benefit to someone else or to yourself. So just to be clear, this court has stated in Abbey, this was the Sixth Circuit case from 2009, that corruptly means, and this is in the context of 666, that an act is done with an intent to give some advantage inconsistent with an official duty and the rights of others.
Did the judge advise the jury about that in the instructions?
The judge followed, and the judge instructed, this was on page 1342 and 1343, that the judge instructed that she had to, that Josette Buendia had to act wrongfully and with an improper motive or purpose, and while not required, he also stated that there had to be proof that this was a conscious wrongdoing. And that, frankly, is the language that Buendia was looking for. So here, the breach of the duty...
I'm wondering how you would respond to Judge Larson's question. The question, as I understood it, was, what if a different kind of paper was used with that excess money, or let's say, you can change the example a little bit, gloves were going to be provided for the cold hands of these people, so they'd be able to write on the paper more easily. All right? How is that corrupt if that's actually what was going on? It's corrupt because it was benefiting whom?
As I understood Judge Larson's question, it was if she could go to Staples and get the paper at half off, then by going outside of the competitive bidding process, is that corrupt? And my answer...
So let's say Norman Shai says, you're going to give me a purchase order for $1,000 worth of paper. I'm going to deliver $500 worth of paper, and I'm going to give you $500 in Staples gift cards. And she goes to Staples and she buys twice as much paper. So now the kids have, double the paper that they ordinarily would have had. Corrupt?
At that point, it is still corrupt because you're using Munn's...
To Norman Shai.
It's a benefit to Norman Shai, and you're also using...
The money.
You're using money that you're not supposed to be using in a way that's outside of the process.
Benefit to Norman Shai?
Well, in this case, the benefit was there was a 40% markup. I mean, he was keeping...
It's just his profit from the 500 that he didn't turn into credit card.
Correct. That,
Bid against the other Norman Shais.
correct.
That's what confused me about the facts, because it seemed like he was keeping track and making sure that they weren't out what they otherwise would have paid, but that didn't help him because, that was still corrupt because he was getting an advantage by facilitating their ability to do that.
He was getting advantage, and I would note, this is on page 4 of my brief, that this is Exhibit 13B that actually shows the ledger. There was a 40% markup. So these are purchase orders in which no goods were delivered. He was keeping 40% and then kicking back the remainder to Josette Buendia. So the benefit is that he's getting purchase orders that he shouldn't be. He's not delivering any goods to the schools, and then they're basically divvying it up. So even if she's taking 100% of the money she's receiving, and I'm not conceding she was, but even if she was and spending it all in the school, Norman Shai is still getting a kickback or is still keeping some of that as profit, money that he's not entitled. That's corrupt.
Let me ask you another question. I concede at the outset that it's not relevant. I'm just curious. We see some awful fraud schemes that are really terrible and selfish and harmful. Is there... What would govern a prosecutorial discretion decision to prosecute a case like this over some case that would cause a lot more harm?
Your Honor, I would...
Or a prosecutorial discretion. It just didn't jump out at me as a terrible case.
Your Honor, I would note that this was in the context of a much larger scheme. Obviously, in fact, Buendia in her third issue tries to make reference to that and enlarge this beyond what it is. Norman Shai was paying bribes to 13 or 14 different principals throughout the Detroit public school system. In fact,
You happened on this and didn't feel like a prosecutor is thinking, yeah, I can sympathize with this lady a little bit, but it's part of a scheme that we've come upon, and it's against our principles to disregard it? Is that how the prosecutorial discretion? Maybe you just don't know, and you just have to prosecute what you're told to prosecute. But.
Your Honor, I think part of that would require us to accept her after-the-fact rationalization that she was doing this to benefit the children. There's no evidence to support that. So if that were the case, that's a different story, and perhaps prosecutorial discretion would come into play, but this is not that case.
Well, they found all this other proof in Shai's house or office or whatever, that he was doing this with a lot of other schools.
Yes, Your
A lot
Honor.
of other people.
Yes, Your Honor. And those principals, to be fair, were doing much more with the money. There was reference, in fact, Buendia herself used in cross-examination, there was reference to the fact that one of the other teachers, or one of the other principals of another school had gone on trips to Las Vegas, another one had bought a Maserati. Those are obviously much more glaring examples, but the fact is these principals had a duty to Detroit public schools.
I'm just saying if you have 10 principals, the little lady who's buying gloves for cold kids doesn't seem like the guy who's going to Miami. That's not a legal observation.
Absolutely, and that would be a much better...
That's why you have prosecutors who use judgment, I think.
That's right, Your Honor, and that would be a much better discussion to have if there was evidence that she was doing that, as opposed to that those were being provided by charities. And that's the problem, is there was no evidence to say that this kickback was used to pay for this money. All of the issues that she said were excluded were all generic. There were kids with issues, and there were things done to treat that, but there was never a connection between the money she received, the $47,000 she received from Norman Shai, and the benefits to the schools. And without that, it's not relevant.
Okay. Thank you, counsel.
Thank you.
Your Honors, I want to make one thing perfectly clear on the last point. Not only were there thousands of receipts that we proffered as evidence, but we also had those organized by an expert named Jim Hoppy, a former FBI agent, into a readable chart as to how the expenditures were made, what they were for. So the notion that there was no evidence of how expenditures were made is simply contrary to the record and the long proffer that was given by trial counsel. It's a small issue, but I wanted to point that out to the court. But Your Honors, I think that was a remarkable concession that was just made by the government, that going outside the procurement process is in itself corrupt. And that's kind of the point in the analogy to Rooney, because where the government stands to benefit, the purpose of Title I funding to improve the academic performance of underprivileged youth happened here. We proffered evidence of attendance going up. We proffered evidence of grades going up. And, you know, the government, and I don't say this with that.
Shai is doing something wrong, though, right?
I'm sorry, Judge.
Shai is doing something wrong, though, right?
Yes, and
and thereby getting business that he might not otherwise get by giving these principals the power to do something they might not otherwise be able to do.
First of all, the first time that the government has made the argument that Shai's benefit is what's pertinent to the analysis, but I don't think you can impute corrupt intent from Shai to conscious wrongdoing for Josette Buendia. So this
Doesn't it say to benefit oneself or another? So she knew that he was benefiting at a minimum.
If we were allowed to make our defense and that was the rebuttal, then maybe that proof wasn't in there. The proof was that she was receiving a award. That's how the proofs came out. So that's a record that we don't have. Perhaps that would have been their rebuttal if we were permitted to put on our defense.
But she took this money and went out and gave it to a street person, a beggar on the street. Could she put that in and say it wasn't corrupt? I was just trying to help a poor old beggar out on the street.
You know, Judge Seiler,
What you're saying, she could say, I gave it to my church, or I gave it to something else, you know, a poor veteran who's...
I thought about that exact question on the walk over here, and it's a fair one and a good one. My thought would be that the funds here, the proffered evidence, were used to benefit the government program that was being funded. If we look at the purpose statement on Title I, It's to increase and improve academic performance of underprivileged youth.
But there are policies about how that's supposed to be,
Absolutely.
right? And she didn't follow those.
I 100% agree with that, and that's why I think the concession from the government just now is remarkable, that going outside the procurement process is in itself corrupt. And that's what happened in Rooney. And Judge Rogers, I respect that the Second Circuit opinion is the one I'm relying on, but I think it is illustrative. In Rooney, you had a lawyer, a private lawyer, who had approval from the Federal Housing Authority to get loans to finance a construction job. Rooney, this lawyer, told the general contractor, I will not apply for additional funding unless you build me a pond, which benefited his land, but also the project. So the Second Circuit, I thought, aptly asked, what if this project turns into the Taj Mahal? How is the government harmed? In other words, that's relevant. What if this was the best school in the United States? And this school was becoming one of the better schools in Detroit. So I think that it is beyond, I think it is fair to say that as a corrupt intent analysis goes, that how the money was spent and her conscious thought about what she was doing with the money is relevant to whether that was wicked or evil or conscious wrongdoing. And the legislature...
Does the people she's helping are also people that Title I helps? Is that the idea? Otherwise, you have the beggar example.
Yes, and that's the question I thought about, and yes, and I think that's the answer, Judge, because that's exactly how Rooney came out, that it benefited... I'm sorry, Judge?
Those benefit the teachers, but those aren't Title I recipients.
Agreed, Judge.
In her theory, she's using the massages to have a teacher relaxation day, which God knows teachers need relaxation, but they're not Title I benefits.
Among other things, Judge, I would point to the evidence we wanted to put in about the roof and graffiti with sexual references that were taken down and all the other things, but I think that would go to benefit the students because we saw results from her actions. And I just want to conclude with, if I may, and I won't take a long time, I promise. I want to conclude with this Robin Hood theme that has been used not only in this court, but also parading around on national television with the evidence in this case about her being Robin Hood and comparing her to the principals who brought Maseratis. At every step of this litigation, including their brief to you, the government has mentioned how she spent the money. They put that in evidence, they used it in their closing argument, and we were told that we can't rebut that inference, whether it's relevant or not. That is not fair. She was defenseless to an allegation made by the government of the United States in their indictment, in their opening statement, in witnesses, in this brief, all throughout the litigation. The only just result here is to remand, and whether you find relevancy or not, is to remand and allow Josette Buendia to put on a constitutional right of defense. And I appreciate your time, Your Honors.
Thank you, counsel. We appreciate that. I see that you are appointed under the Criminal Justice Act, and we appreciate your taking this case.
I'm grateful you were saying that, Judge. Thank you.
That's the last case, correct? You can
Correct.
go ahead and adjourn the court.
Absolutely.